Good afternoon, everyone. We are Cannabis Legal Group, and welcome to Cannabis Live, episode 84. My name is Nickolas Galendez.
And Jennifer Domingue.
Today we're going to talk about two subjects, primarily the crackdown on CBD sales amongst the different states and whether or not that's going to impact Michigan. And we're also going to talk about different forms of delivery under the MMMA, MMFLA, and the MRTMA, and what things could potentially look like in the future. I think first we're going to kind of start off with just a little bit of a news update of something that happened in Mount Pleasant. Jennifer, if you want to kind of give us a brief overview of that, we can kind of talk about that a little bit.
Sure. So Mount Pleasant had a recent lottery for issuing their medical marijuana facility licenses. They had, I believe, 58 individuals who applied, well, actually probably more than that, and the city decided that they were going to allow 57 of them to enter into this lottery. There was 2 court cases that were filed in opposition to this, and the court granted one petitioner and denied one petitioner, basically allowing an additional applicant to be entered into the lottery. And so then there was 58 total. And the city has awarded 3 licenses conditionally. And now, so we have 3 conditional approvals, and the remaining 55 of them would be pending. And so they're up in the queue. And so if you didn't get your Mount Pleasant license, then you wait until your name is called if other people fail before you. But that's the way that Mount Pleasant has chosen to do their system. It is interesting to see the way that the different municipalities have chosen to evaluate the license applications, or whether they just want to do a lottery system, a merit-based system, and what those different municipalities are choosing for what would be the most fair and equitable way to review their applications.
And I think the whole Mount Pleasant lottery system and what's kind of played out is a little illustrative for 2 points. The first one being when municipalities think about whether or not to opt in, how they're going to accept applications, if it's going to be a competitive application process, there's several ways for them to kind of go about it. And I know that a lot of things going into that are, how do we want to make it fair? Do we want to have people from our communities have a few more points to encourage local investment? Do we want to do something that gives us the less risk of being sued and having litigation in connection with this? And if you look at the competitive application processes that have played out in Lansing, I know that things were stalled there based on the way things were designed, as far as wanting to make sure all those applicants who had appealed had the opportunity to do so before they fully issued all their licenses. Potentially now with Mount Pleasant, you see litigation over the lottery. Potentially, I know Grand Rapids is going to open up soon, so you might see potential litigation there, or potentially appeals that stall the application process out. So I think that's one thing. And then also just to discuss, and I kind of glossed over a little bit, just the different ways municipalities can go about this process as far as selecting applicants.
Absolutely. So there's still a lot to be learned while municipalities decide how they want to really review these applications, significant hurdles that each of them face, because it really is dependent on the local culture and what they're looking to promote. Is what a larger city is looking for in an application might be drastically different than what a small municipality is looking for. So we certainly are seeing certain municipalities favor certain aspects of the application process over others, and it's really interesting to see how that develops. So that's the really big news for Michigan this past week, but there has been a lot of controversy right now regarding CBD nationwide. And there is a crackdown that seems to be happening in multiple states right now.
Yeah, so I mean, it's kind of been making the news rounds this past week or so. The states of Maine, New York, Ohio, and North Carolina started kind of cracking down on the illegal, what they deem to be the illegal sale of CBD and CBD products, banning the sale of foods containing CBD. And I think the biggest issue here is, when we're talking about adding that substance to something we determine legally as food, it's considered to be a food additive. And so is it safe for human consumption? And basically, the way that at least from a federal level, they kind of qualify it is that a food additive is any substance that you can reasonably expect to directly or even indirectly affect or become part of a food. So certainly, if you're talking about infused drinks, if you're talking about edibles with CBD in it, that would be considered something that would be a food additive. And with food additives, there need to be certain more considerations that are put into play, more so now that the regulated market is starting to develop both federally and at the state level. And I think this is where we're seeing certain states making a health and public policy decision as to whether or not they should continue to allow these being on the shelves, or if for the public safety it's worth kind of clawing those back and really making sure that what is released is 100% proven to be tested and safe for its intended use.
Absolutely. So the thing about the Food, Drug, and Cosmetic Act is that the way the federal government chooses to look at these things is it's not safe until it's tested and proven to be safe, versus the opposite, which would be that we assume it's safe until we have issues that arise later saying, well, actually, we're just kidding, it's not actually safe, and so we're going to take that off the shelves. So right now, because there hasn't been a lot of testing that has been conclusively done on the federal level, because it's been banned for so long, we have this kind of, a knee-jerk reaction with states saying, whoa, this doesn't really comply with the Food, Drug, and Cosmetic Act, so we're going to crack down on these proprietors, these businesses that are selling CBD-infused products that may be consumed.
Mm-hmm. And I think it's just kind of, semantically, legally, we're making distinctions here, with food that hasn't been, food additives that haven't been deemed safe for those intended purposes. Mm-hmm. It's considered adulterated. That's subject to enforcement action. And so I always like to use the analogy to speeding. When people are going over the speed limit and other people see that happening, more people will tend to do that because nobody's getting in trouble for it and it's just not being enforced. And that could be a situation where even though it's operating outside of the laws, the police aren't pulling people over for it, so to speak. But it doesn't mean they can't. It doesn't mean they ever won't start to increase pulling people over. There's a lot of kind of factors that can go into that decision as far as when to pull people over and when to ticket them, so to speak, for this kind of conduct. And what we're seeing in Maine, Ohio, and New York, and North Carolina, to name a few of the states that are starting to take action, certainly kind of signals for those states where they haven't signaled that yet. Despite the federal legality of CBD-derived hemp and hemp from an industrial standpoint, there's certainly still a lot of things that need to get figured out now and decided before these things are for sure 100% safe and not subject to any kind of enforcement action or disciplinary action.
Right. So we are looking at a new thing right now where CBD might be considered more of a dietary supplement, which wouldn't be regulated by the Food, Drug, and Cosmetic Act. So you might see a lot of dietary supplements in different stores, health food stores, supplement stores, and you'll see on the label that these products are not meant to treat, diagnose, prevent, or cure any disease and haven't been tested or regulated by the Food, Drug, and Cosmetic Act. So we'll probably be seeing more CBD products fall in line with that in the short term. And if you are thinking about running a CBD business, you certainly want to make sure that you put that statement on all of your CBD items.
Mm. And that's the other thing too. We're making a distinction between CBD that is added to something considered to be a food product, and CBD potentially not marketed as a food, but more of a supplement to your nutritional intake. While that might not have the same stringent requirements as a food additive, if you use it as a supplement, it's still considered a new dietary ingredient. And so if it doesn't check those boxes in terms of how the FDA regulates these things and how all these other governmental agencies regulate these things, then it's still going to be considered unadulterated, potentially misbranded, which is also subject to enforcement action. So kind of similar right now to after Prop 1, where adult use marijuana is legal, but I can't buy it anywhere. Just because hemp and CBD, from the federal side of things, under federal law, the kind of floodgates have opened up, so to speak, and it is legal from a federal standpoint, there's still a lot of things that need to get worked out before the system can fully work, before CBD tested and regulated products are fully out on the market. And I think right now, there's a kind of give and take between the regulators and the public, where these products have been sold for however long on shelves, and some of them are helping people, some of them aren't, just snake oil with CBD labeled on it. But the thing is that you can't tell for all of them across the board which ones are safe and which ones aren't. And I think you're seeing more and more states coming on board with the fact that we need to get these off the shelves for the public health, safety, and welfare. And then once we do have a mechanism for licensing this type of conduct within the state, for importing, for exporting, then we'll be able to safely say that they've been tested as a food additive, as a new dietary ingredient, and then those can be put on the shelves for consumers to safely consume, I think is the biggest part. So, Jennifer, do you think it's going to happen in Michigan? What would your gut feeling say about that?
I would say that a crackdown might happen. The current government administration that we have right now in Michigan is certainly very pro-cannabis. I think that they are looking to increase interstate commerce, and so a crackdown might not be as likely as in the more conservative states. However, I would anticipate Michigan to start pushing through the hemp processor handler license applications, as well as the hemp grower license applications that will be needed in order to process CBD from industrial hemp. I could see that happening relatively quickly, and so at least Michigan will have some sort of regulatory scheme in place to monitor the CBD products that are being manufactured and processed within the state.
And I think to take us back to that point, back in May of last year, the department issued a bulletin about CBD and hemp, explicitly saying that these sales cannot happen unless you have a license under the MMFLA or potentially the MMMA as far as those patient caregiver transfers are concerned. Obviously, a lot has changed since May 2018. Prop 1 passed in November. The Farm Bill passed at the federal level. And so now we have a little bit of a distinction, but as Jennifer mentioned, there are still different mechanisms that need to work, that need to kind of fall into place before you actually are able to sell it legally, whether that be growing hemp with a grower registration under the Industrial Hemp Research and Development Act, whether that's being a processor handler under that same act for hemp and CBD products, whether you're a licensed MMFLA processor and actually extracting that from the industrial hemp. There's all these different things that you might need to do before you're actually selling these things that might not have been enforced previously, that are now going to, if we're taking the signal from other states, start to become more enforced, which if you hold a license for just a business license, or if you have something on the line or you're planning on applying and you're selling these things in violation of rules, that could be something that you should take into consideration if you're going to potentially pull them off the shelves, to show good faith that you're trying to comply with these laws and regulations as they change.
Absolutely. So I think the biggest takeaway here is be careful how you're marketing your CBD products. Be aware that a crackdown could occur. And you definitely want to make sure that you get your application in for handling hemp products or CBD products once that application is available. Right now, the state hasn't released that application. There are no administrative rules drafted yet about this new license type. That being said, you definitely want to make sure that you're one of the first ones in line. So that is kind of the main takeaways from this crackdown on the federal level as well as on Michigan's level. And we're not done yet. I know there's been a lot of discussion about CBD, but there's been even more discussion, I think, about delivery of cannabis. And so I think we're going to just kind of dive right into the differences between the delivery formats under the three main cannabis laws in Michigan. Nick, do you want to talk about that a little bit?
Yes, I do. So, that is true. We've been getting a lot of questions. And so one of the most important questions we get is, I want to deliver. Okay, but you need to let us know when you're asking that question is under what model. Some people come to us as a caregiver wanting to get into the industry. Other people come as small business people, multi-state operators, so on and so forth. And so for each business plan that you might have, delivery is kind of a vague, more general, ask. It's I want to deliver under the MMFLA. I want to deliver for adult use, and depending on your question, that kind of dictates the answer. So obviously in Michigan we have three different laws: the MMMA, which is patient caregiver; The MMFLA was as commercial licensed medical marijuana facilities, and then the MRTMA, which involves adult use, consumption, delivery, possession, and licensed facilities. And so some of those rules are fleshed out. Some of those rules are non-existent to a certain extent on a commercial level, and some of those just are to be determined. And so I think it's important to kind of go through all of those again, just so everyone's sure and kind of refresh everyone's memory about exactly what kind of delivery can happen under what different type of framework.
Right. So just to kick us off, let's start with the MMMA, the Michigan Medical Marijuana Act. That was enacted in 2008. And under that framework, we have a patient and a caregiver, and the caregiver could grow marijuana or obtain medical marijuana and provide that to a patient. But does that mean that the caregiver is effectively delivering that marijuana to the patient? And if so, are they protected? And under the MMMA, there's not really like a delivery aspect to this. It's implied, they understand that between a caregiver and a patient, there's going to be a transfer of the possession of marijuana, but it's not really explicitly stated that we're going to have a delivery occur. And so the best that the MMMA can do for you is give you a protection. There's the two protections, the Section 4 and Section 8 defenses, but you can have a transfer to a patient of no more than 2.5 ounces of usable marijuana, and you can only have that 2.5 ounces on your person. And so if you're handing that over and you're driving with it and you get caught, if you're like delivering that to a patient, you have to show that you have this usable marijuana, it's less than 2.5 ounces, you have your caregiver card, they have their patient card, that sort of a thing. And so that's really the only delivery component under the MMMA that's applicable to you at that point in time.
And we definitely used to get this question a lot more, a little bit closer to when the MMFLA application process had just started up and running. Similar to the speeding analogy, there were some companies and some individuals out there holding themselves out as delivery companies. And obviously you mentioned Section 4 immunity, there's also a Section 8 defense, there's a gray area around that, a part of the law still, which arguably some people were using or at least potentially operating under, where they were delivering to other patients under that section for their medical use. But in terms of actually having that hat on as a delivery person, I mean, if you called me up and said, hey, you want to deliver me some food, I'm real hungry, maybe you're sick and I can't get out, do you mind doing that as a favor to me? I don't conceptualize that as delivery. I mean, it's, I'm doing you a favor, I'm being nice, I'm giving you something you asked for.
Right.
That's kind of similar to how the patient-caregiver delivery system is supposed to work. As the caregiver, you're growing that marijuana for the medical use of that patient, and if you happen to want to deliver it to their house, you do that. There was never any kind of commercial for-profit model that was intended for delivery purposes under the MMMA, and I think it's pretty clear soon, and especially moving forward, that type of model certainly wouldn't have a lot of legs and would be subject to potential charges if that were to happen, civil infractions and things like that, or beyond doing it for commercial gain. So certainly under the MMMA, strictly confined to patient-caregiver transfers. Delivery just might happen, if you want to categorize it like that, as me as the caregiver getting in the car and driving it over to my patient's house.
Right.
Obviously for the MMFLA, there was a little bit of a nothing in there initially about delivery in the emergency rules moving on. And then eventually with the more permanent rule set, Lara ended up deciding to open it up to delivery. First there were a 3-patient limit as far as how many times a licensed provisioning center employee could go out and deliver to a patient per trip. Eventually in the permanent rules though, they did open that up. So Jennifer, if you want to kind of dig a little bit into the MMFLA delivery method, which is a legitimate license type of avenue, which you can get that product out to patients, especially in areas I know where they don't have any licensed provisioning centers and they haven't opted in yet. So this is a very viable option.
Absolutely. So under the current MMFLA framework, if you have a provisioning center, then you can have an employee basically do home delivery. And the home delivery aspect is while it kind of sounds like a pizza delivery sort of a format, it's so much more than that, because not only is the state checking your route, they need to know what addresses you're going to, the route that you're going. You need to have a GPS in your car that's going to be monitored and available for access by the state. They are going to be checking if you have to stop for gas. You have to write that in, that you're stopping for gas and where you're stopping and how long you're going to be stopped for. And the state is really kind of keeping a close eye on how these delivery drivers are functioning, how they're, where they're going, how long they're out for, and they can only deliver up to 10 orders in a trip. So if you're thinking to yourself, well, you know what, actually I'm just gonna have this part-time employee come in and the last 2 hours of the day, they're gonna take all of the online orders and they're just gonna go and deliver 30 orders in the afternoon or in the evening. That's not gonna work. They only can deliver up to 10. And they can only accept either cash at the door or it has to be paid online. The driver has to make sure that they double check that it's a patient receiving the medical marijuana. It can't even be a caregiver, I don't believe, under the current rules. It says very specifically that it's for a patient only, and they have to confirm that they have their valid patient card. So the state is really kind of cracking down on how they're going to do this. It's a very closely regulated scheme right now, but it's one that certainly opens a lot of doors, because if this works and it works well, then that really opens the door under the new adult use law.
Mm-hmm. And I definitely think these added extra safety concerns above and beyond what they have in facilities is warranted. And if you're talking about having employees going out and driving company vehicles or potentially even their personal vehicles out in the open, certainly won't have the same restrictions imposed on them as secure transporters. So, if an employee is going out on their own, there's some certain safety concerns that might be there that aren't there for an established licensed facility with all of those cameras pointing at every entrance and exit, constant monitoring and security. You're a little more on an island if you're delivering to 10 patients. Certainly those deliveries are going to have to be under the daily limit and under the monthly purchasing limit. So one delivery person from a provisioning center isn't going to be bringing 300 pounds in their Ford Focus down somewhere where they could potentially lose a lot of valuable product and also have their safety compromised. But it's definitely kind of, smaller deliveries, definitely there to serve those unserved areas that do need delivery, especially for those patients with chronic and debilitating conditions. They can't get out of their houses. Delivery is going to definitely be a godsend for those people. So I really applaud the Bureau for allowing that and really listening to industry in terms of adding that to the rules. And certainly for opening those up from the 3 to the 10, because I think that it has to make sense from a business standpoint as well. Obviously, you get more per mile if you can get more profit per purchase and serve that certain number of people more effectively by doing that with a bigger number than with just 3. If you can imagine the logistics that would cause, you'd either need to have 10 employees to do that or significant amount of stops in between. So definitely a step in the right direction, but how about for adult use? Delivery for adult use, is that something I can do right now?
No. Well, and that's for multiple reasons. First, we don't have that commercial framework in place yet for adult use. And so we don't have commercial places that can have a delivery system. So this is all kind of up in the air until the state drafts their administrative rules. Right now, we don't know if a provisioning center or micro business is going to be able to deliver. I anticipate seeing something similar to the provisioning center delivery model under the medical marijuana law to be implemented under this new adult use law. But we can't say for certain right now. I think the state is certainly going to be learning some lessons and taking note of that over the next couple of months, seeing how things start to expand and grow into the medical marijuana industry before they decide to implement it in the new adult use industry. But it's definitely something that I can certainly envision happening for at least the provisioning centers. Micro businesses, we'll see. I would like to see micro businesses have the option to deliver, but that being said, that's more up in the air. Because it's such a small niche market, I don't know if that will extend out to the micro businesses, but it would certainly be, I think, a smart play on the state to add that in.
Mm-hmm. And how about if I just want a gift? Can you deliver me a gift? Is that allowed?
Well, you can have up to 2.5 ounces on your person and then gift it to another person. So as long as it's me driving with 2.5 ounces and then gifting it to you, then there's really no problem there. Now, what there is a problem with is if I am a pizza delivery lady and an incentive for you to purchase one of my pizzas is that I gift you marijuana upon receipt of that purchase. So when I give you the pizza, then I also give you some marijuana, and maybe my pizzas are so good they cost $150. We can't do that, right? You can't deliver marijuana in that context. It's not going to be allowed, especially if I'm advertising it or promoting it in any sort of way. Because let's be real, the pizza probably isn't worth $150. It's starting to look suspiciously like the sale of marijuana, and that's just not allowed under this framework right now. So delivery for a gift, that's okay. It's when you start promoting it or advertising it that it's a gift if you make another purchase. That's when it's maybe not quite as allowed.
Yeah, so if the gift itself is tied to some other kind of strings that offers another product or service that might make it seem like it's an end around to actually giving somebody weed for money, which is prohibited under Prop 1, something you want to make sure you stay away from, stay within the confines of the different laws that we're operating under now. It's a little bit similar to how I was mentioning conceptualizing caregiver-patient delivery. We're both adults. If we both happen to use cannabis and I happen to want her to deliver me some cannabis that she might have if I run out, she drives over and gives it to me. That's just a friend helping a friend out. That's not a delivery type service. She's just dropping some product off to my house, which is fully allowed under the law, versus a for-profit commercial delivery system where you're engaging members of the public. Definitely something you want to be careful about just to make sure you fall within the confines of the rules. So it seems like as we continue to develop this industry, both on the CBD side of things and the cannabis side of things, so as far as delivery goes, there's certain things that are just going to need to keep getting decided by the regulators, by the operators that are licensed now, as well as the interested general public.
Possibly even additional license types created by the state. I've had a couple of people ask me if they could start an app like an Uber Weed or like a Weed Hub. Instead of Grubhub, you have Weed Hub. Instead of Uber Eats, you have Uber Weed. And I'm not saying that can't happen. I'm saying it can't happen right now. The way the new law is written, the MRTMA is written, is that the state has the ability to draft rules and implement new license structures for additional license types, such as a delivery system that's just delivery of marijuana and cannabis products. They could implement licenses for social consumption. We've talked about that before. We've talked about how there might be an additional license type for an event. You know, you have an event space, and then when you have a certain license type, you can have weed at your event.
I saw something about a Kush cruise or something like that, like a booze cruise, but with cannabis on it. Right? So there's all these types of different ideas that you know the industry allowing to open up and come from under the shadows and actually be here is really inspiring a lot of creativity and entrepreneurship, and this is definitely something that makes it exciting to work here and work within this industry and see it developed and help shape it. The other side of that that's more frustrating is that when there's things that are unclear or people trying to push the limits, which then just kind of can lead to trouble. So while definitely all the innovation and the ideas are helpful and are worth discussing with the lawmakers and the regulators about, it's pushing those boundaries that I think make a good idea turn down more so than it would be if you had asked and really presented it in a great way and then waited until it was fully legal. Because you definitely don't want to be that one bad apple that ruins the bunch. But there are certainly so many interesting ideas like the Kush Cruise and all these other different things that could potentially be allowed in the future if these licenses become up and running and created by the department?
So that's probably not going to happen in the next 6 months. I certainly wouldn't expect it to be when they issue their administrative rules the first time around. This is probably something we're going to see in the next 2 years, 5 years, certainly down the road, but we're just not there yet. So make sure to stay talking to your state representatives, your senators. They're going to be helping to, implement laws that may allow for this. Talk to the department. If you're in the industry, talk to Lara. They have the authority to issue rules to govern this. And certainly stay tuned for our weekly Cannabis Business Live show, because we'll always be coming to you with the latest and greatest updates in this industry every Friday at 2 p.m. Thank you.